It's 3 o'clock and time for Senate Judiciary. Members and audience, we're being televised today. Mr. Clerk, please call the roll, establish quorum.
Chairman Jones?
Here.
Senator Shoemaker? Here. Senator Rocca? Here. Senator Beda? Here. Mr. Chairman, you have 4 members present, a quorum.
I'll make a motion to adopt the October 10, 2017 committee meeting minutes. Without objection, they are adopted. First bill up is 4756. This is a Lucido bill. This is identical to my Senate bill 510. We've already voted it out unanimously. We found out that his bill was turned in before mine, and they simply didn't move it as fast in the House, so we're going to run his bill all the way. Does anybody have any questions? Seeing none? Oh, we have the Michigan District Judges Association here in support. And we have Supreme Court Administrative Office here in support. I'll make a motion to report House Bill 4756 to the floor with the recommendation the bill then pass. Mr. Clerk, please call the roll.
Chairman Jones?
Yes.
Senator Shoemaker?
Yes.
Senator Rocca?
Yes.
Senator Beda?
Yes.
Mr. Chairman, there are 4 yeas. The bill is reported.
I'll make a motion to recommend immediate effect. Without objection, immediate effect is recommended. Now we're going to take up Senate Bill 630, and I would invite up Supreme Court Administrative Office to explain why this is needed. Tom Clement.
Good afternoon, Mr. Chairman, members of the committee. My name is Tom Clement, General Counsel for the Michigan Supreme Court. This is a fairly straightforward bill that deals with how MIPs, where there is a failure to comply with judgment, are reported to the Secretary of State. So previously, where a first offense MIP was a misdemeanor, if that MIP, if there was a failure to comply with the judgment for that MIP, there was a 14-day notice immediately sent to the Secretary of State. If the failure to comply continued, there was a license suspension. Now a first offense MIP is a civil infraction. So we want to treat that civil infraction like every other civil infraction, where the defendant is afforded, the respondent is afforded 28 days to comply with the judgment. If they don't comply with the judgment, then the 14-day notice hits, and if the 14 days passes, then there would be a license suspension. So it takes a first offense MIP, which is now a civil infraction, treats it like every other civil infraction. That's all it does.
Very good. Any questions? Seeing none, thank you very much. I'll make a motion to adopt the S1 version of Senate Bill 630. Mr. Clerk, please call the roll.
Chairman Jones?
Yes.
Senator Shoemaker?
Yes.
Senator Rocca?
Yes.
Senator Beda?
Yes.
Mr. Chairman, there are 4 yeas. The substitute is adopted.
I'll make a motion to report the S1 version of Senate Bill 630 to the floor. A recommendation the bill then pass. Mr. Clerk, please call the roll.
Chairman Jones?
Yes.
Senator Shoemaker?
Yes.
Senator Rocca?
Yes.
Senator Beda?
Yes.
Mr. Chairman, there are 4 yeas. The bill is reported.
I'll make a motion to recommend immediate effect. Without objection, immediate effect is recommended. We'll now take up Senate Bill 527, Senator Casperson. And the last time we met on this bill, you were going to work on the language.
Thank you, Mr. Chairman and committee members. Yes, we have been working on the language. Been trying to pull both sides as close together as we possibly can. There has been some changes made on behalf of the department. Certainly some of the gun groups have pulled together. Some of the division has been definitions. So what does a word mean? And the problem we're running into, or have run into, is depending on who is going to go into a home and decide what's legitimate and what's not, if they go in with a bias to start with, if they go in not liking guns to start with, if we don't spell it out as to the do's and the don'ts, then we end up back where we are today, in a sense, trying to figure out how to do this. So what we've tried to do is really tighten down what each definition means. When you're talking about carrying a firearm lawfully, and we're talking about, and this bill is designed around people that are law-abiding citizens that have a right to have firearms. We're not talking about criminals or somebody that's not supposed to have one. So what we've tried to nail down is the possession of a firearm, carrying a firearm on your possession, as long as it's done in a lawful means, you're good to go. And we have to do that, Mr. Chairman, because if we don't, we end up with stuff like I have in my district with a sheriff who's been restricted. I think you'll hear some testimony of even more restrictions on the sheriff that we didn't know about concerning his vehicle. And so that's why we've tried to really nail it down and be very specific. And as I've read through the bill in detail, it came to my attention that if we started out with the premise that you're innocent, you're a law-abiding citizen, started with that premise, and then went in and checked out the home, we probably wouldn't need a lot of this language. But what's happening is that's not what's happening. And so we have to spell it out, what certain things mean. The hunting issue was a big issue, whether or not a foster child could go out hunting with the foster parent or go to the shooting range with the foster parent. People that do those things for recreational activities, they look at that like some people would look at going to a baseball game or going to hunting or going golfing. They enjoy going to the shooting range. They don't look at it any different. So it shouldn't be any different for a foster parent if that's what they want to do and the child wants to go with them, and they're supervised with the foster parent. There shouldn't be a stipulation just because there's firearms involved that we're not going to let you do that. And so that's what we've tried to do with the language. As I said, I think we've gotten a lot closer. I just had a conversation, there's still some concerns, but it gets into that gray area again, Mr. Chairman, that somebody's going to make the call if we don't define it in the law. And so who are we going to let make that call? And that's where it is. Now, if there's some type of liability, I thought in the bill we tried to protect the department from lawsuits. If something, tragedy happened, and we certainly don't want that, but if something did, they shouldn't be held liable because we passed a law that allowed for, let's say, the firearm to be in the home. I get that. But if the department is going to be held liable simply because somebody doesn't like the fact that there are firearms in the home, even though they're secured and people follow the law, maybe we try to help them so that they can't be sued, much like we did with the Castle Doctrine. You and I did that, Mr. Chairman. Protecting someone that's lawfully defending themselves should not be then sued in civil court because they did that. If that's what the department's concern is, then maybe we could find a way to help them with that. But taking people's rights away from them because they're concerned about it doesn't make sense to me. So I'm hoping we have support and that we move forward. Not everybody's happy, as I said, but a lot of groups did come forward and did come on board with the changes we did make. And with that, I'd entertain any questions you might have.
Well, Senator, I certainly agree with you. I'd much rather have young people out hunting than playing violent video games that where they kill police officers and attack people, and certainly a lot of violence in those, and much better to have them out turkey hunting. Do we have any questions?
I'm sure the turkeys don't care.
Do you eat turkey, Senator?
But I don't shoot them. I do it the lazy way.
Yes, you may
I
ask a
order
question.
them. They don't look anything like a turkey by the time I get it on my plate. Actually, I do have a question because I know there's a lawsuit going on, and I'm always a little hesitant about doing legislation in response to a lawsuit. Where is the lawsuit at, and what is the status of the lawsuit, and when might we find a decision on it, and what would be the argument about waiting until the court comes down? Because the court very well might come down on what you're trying to do right here and might give us some guidance as well.
Yeah, it's a good question, Senator. I don't know the answer to that, but if the department comes up to speak, they would be able to talk to that. That's been the conversation that we've had, though, is how do we avoid the department? How do we avoid folks from just suing us because they see us allowing things because they have to, because of the law? I certainly can understand that, but at the same time, a lot of people disagree with us on a lot of things, but if the law is the law, they shouldn't be held accountable for that, for following the law. In fact, I would argue that's probably been the argument in this town that I've made more than anything, is that I want the departments to follow the law. And so I think they'd be better served to answer that question, because I don't know exactly where it's at.
Okay, thank you.
Thank you, Mr. Chairman.
Christine Rahagen and Patty Neiman of MDHHS.
Thank you, Mr. Chairman. I'm Chris Rehagen, and I am the Director of the Division of Child Welfare Licensing. Patty Neatman is the Program Manager in the Division of Child Welfare Licensing. The Michigan Department of Health and Human Services, as we noted last time, is responsible for the care and supervision of 13,000 children in the state of Michigan. The department is also responsible for verifying compliance with statutes and administrative rules which have been enacted as minimal safety standards for licensing foster homes and foster family group homes. The department has very serious concerns about particularly the third draft of this bill. We have reviewed draft 1 and 2 and would like to continue to work with the legislature on clarifying some of the language in particularly draft number 1. The department and the Division of Child Welfare Licensing understands that there are many responsible gun owners in the state of Michigan and who are able to keep children safe. Responsible gun owners typically and often are those that educate their own children regarding guns and weapons and related safety expectations. The topic of weapons becomes more complicated when we need to assure the safety of another parent's child, namely a foster child. Foster children come from many different backgrounds and experiences. Foster children have not received formal gun safety class or may not have been taught by their parent appropriate and safety expectations when guns are accessible in their use. Foster children have experienced various levels of trauma, the extent to which is often unknown when those children are placed in our foster homes. A child's trauma is exhibited in many ways, either through depression, which can result in suicidal ideations and behavior, or anxiety, in which children may experience intense fear when placed in homes that are accessible to guns and weapons. Such a child may have had little to no experience with guns or have been observed and witnessed unlawful or traumatic situations involving weapons. Children may also exhibit impulsive or aggressive behavior, which can be acted upon toward themselves and others. Many times, children in foster homes are also cognitively impaired, which then they demonstrate the lack of judgment and places them in unsafe situations. Some foster children may not be impacted by guns or weapons at all. They may have been taught by their parents and consequently experience no anxiety or depression and perceive them as being normal, everyday activities. As previously noted, we have some serious concerns over the legislation currently being drafted because this does increase a child's access to a weapon, and particularly our foster children who have experienced many traumatic experiences. One of the other pieces that we do tend to experience are children who have delinquency matters and who may be placed in a foster home and may also have probation orders that may impact a foster home having the ability to have weapons in their home. Child may not be placed in a foster home that might have access to weapons. We have experienced several situations in the child welfare system that have been impacted by guns and weapons and children having ability to obtain them within the foster home. One example was two children, a 5-year-old and a 3-year-old. The foster parent in the car had a concealed weapon. Was uncomfortable with the concealed weapon and the seatbelt, took the weapon out, put it in the side pocket of the car. The children got a hold of the gun, thought that it was a toy. The 5-year-old shot his hand accidentally and also shot his sister, 3-year-old sister, in the pelvis. There was another situation in which a teenager who was placed in a child caring institution, licensed treatment residential program, who went on a visit with foster parents, knew where the guns were located in that foster home, was a previous foster home that he had been placed in, was able to access those guns and the ammunition, put them in the backpack, brought them back to the child caring institution. Luckily, there was a roommate who this resident happened to show what was in his backpack after the visit. He notified staff in the residential program, which definitely eliminated a crisis situation from happening. These situations do happen now, even with current administrative rules that we have in place. We are definitely looking forward to continued work with the legislature on clarifying language in the proposed 527 bill, particularly draft 1, because we want to make sure that kids and families are safe in the state of Michigan, and particularly those that we are charged with care and supervision of. I would also like to make a comment about children in foster care who might have the opportunity to hunt with foster parents. The prudent parenting policy allows for that, to have those educational as well as recreational experiences if a child is able to do so and the foster parent is able to do so. The prudent parenting policy does cover that. We would also strongly encourage that there be a review of other current legislation impacting guns so that Senate Bill 527 would match the requirements in gun legislation so that there isn't any conflicting language. Thank you.
Okay, I just wanted to say briefly, I'm aware of people being put on a probation situation where they can't have a gun. I knew of a man's son that got into trouble, and I knew of a man's spouse that got into trouble. In both cases, the judges reversed themselves and allowed them to have a gun safe and just not give out the combination to his son or to his spouse. And so there's usually ways to satisfy that. Do we have any questions? Senator Beda.
We have, you'd recognize that there's a constitutional right to bear arms, correct? Do you say that there's a constitutional right to be a foster parent?
There is a process, a due process in place to become a licensed foster parent, and people choose to be licensed foster parents, but we also have to go along with the process and the application process and assessing to make sure that a family meets the qualifications identified in statute and the administrative rules in order to be a licensed foster parent.
And it's very difficult when you're dealing with finding a foster family for a child. Sometimes they come from very difficult situations, and you have to take a lot of factors into account.
Yes.
I know there's this litigation going on that I referred to in my earlier question, and I'm not sure if you're familiar where it's at in the process. I haven't had a chance to do that. Are we anywhere close to a decision on this matter?
Because of the litigation, I am not comfortable in responding to that question. I'm sorry.
Do you, any idea when it would come down?
I do not.
Okay, thank you.
Okay, thank you.
Thank you.
Bill Hawley of the Delta County Gun Owners Association from Escanaba.
Good afternoon. My name is Bill Hawley, and I'm president of the Delta County Gun Owners Association in Escanaba. Let me start out by saying when I turned in my card today, I was asked how I wanted to declare about this bill, and I kind of said neutral. But after listening to the testimony so far and hearing what's going on, I really, at this point, need to change that feeling or that commitment to supporting it. Senate Bill 527, as it's presented today, moves in the right direction, and we appreciate, Delta County Gun Owners appreciates all the effort that's been put into this. The bill is a great improvement over the original, and we are excited that the sponsor has listened to our concerns that are brought to his attention, and have included many of them in this current version. With that in mind, Delta County Gun Owners does have a remaining concern about the substitute bill, and we feel it needs to be addressed so it's much easier and much closer to protecting the rights of responsible gun owners who are foster parents and the rights of the children that they care for. In sections 3 and 5, the term "in presence of" and "the presence of" is not clearly defined, which leaves it open to interpretation or department policy. There is a potential conflict here. Delta County gun owners would prefer that any definition allowed under current state law regarding firearms and hunting that defines "in the presence of" be allowed under this bill, so that the children in foster care and their foster parents are treated the same way as anyone else with regard to firearms. Delta County gun owners will be looking into the situation and will work with the sponsor to provide a potential solution. In draft number 2, we had an additional concern, which that was the definition of foster child. If you recall, in draft 2, the definition of a foster child was going to be used as placed for adoption rather than adoption and for reunification. After we pointed this out to Senator Casperson, the definition was corrected to include both of these groups with that intent to cover them both. We appreciate that he is working closely with the interested parties to make this a bill that's treating those affected by it the same as anyone else in the state of Michigan. We thank Senator Casperson for his efforts and concern for what's right. In thinking about the 2 incidents that were just talked about a moment ago, both of those incidents were or are addressed in the current bill. The first one, where the woman left, or the parent left the firearm in the side pocket, that gun was left unattended rather than being attended, so that would have been addressed in that bill. And again, the other one where the foster child went to a previous home and came back with firearms, that's addressed in the bill because those guns apparently were not locked up. They should have been locked up according to the information that's in the bill currently. Excuse me. In closing, I'd like to return to the testimony that I made in September hearing about the bill. At that time, Senator Casperson and I both talked about our Delta County Sheriff, Ed Oswald. He was a foster parent, but in order to retain his license, he had to comply with the DHHS policy by locking his service firearms up as soon as he got home, and was not allowed to carry a firearm off duty. And at that hearing, DHHS liaison stated that he could carry firearms. Since that time, I've talked to Mr. Oswald, and he informed me that he has a department-issued patrol car that has firearms locked inside. As well as locking his firearms at home, he had to receive DHHS permission to bring that car home as required by his job. I feel that discrepancies such as this need to be addressed as the bill moves forward. I'd like to thank everyone today on the committee for the opportunity to express the concerns of Delta County gun owners about the bill, and we look forward to working with Senator Casperson to bring a good bill to completion. Thank you.
Any questions? See none, thank you for making the trip. Tom Lambert, Michigan Open Carry.
Members of the committee, my name is Tom Lambert. Thank you very much for the opportunity again here today. I'm very happy to report that our previous opposition to the bill has since been removed, and we do now support the bill moving forward. Senator Casperson and his office has done a fantastic job of working on this bill, and we would like to extend a huge thank you to them. However, there's more that I think the committee needs to hear. This legislation is good stuff, and it needs to move forward, and I hope you do move it forward quickly, but I've had the opportunity since the last committee hearing and this committee hearing to speak with some of the people involved with the litigation that spurred this legislation. And unfortunately, I no longer believe that this legislation is enough to truly fix the issue. I think it's little more than a Band-Aid to address a lot of the symptoms. Good, move it forward, please. But hear me out. I think what's going on is effectively a bait and switch by the department. You're hearing one thing from here in committee, The people out in the field are saying something completely different. And then the Attorney General's office says a third thing in their brief against this lawsuit. It seems there's no accountability at any level here to get the truth of the matter. We've been debating this legislation in the context of whether or not a foster parent can carry a firearm for their own defense inside their home. I've known this issue has gone on for a long time, years and years and years. I've known that there's been an issue with this department for years and years and years. The problem is every time we find somebody with this problem, we say, let's help you out, let's stand up to them. They never want to fight back because they know if they do anything to fight back, their kids will be taken from them. And that's what happened in this instance. And what's going on here, this isn't a matter of whether or not you can carry in your own home. This isn't a matter of whether or not you have to store your firearms in your home. Let's take this specific example of this lawsuit. The gentleman in question wasn't given the opportunity to store his firearms. He was told multiple times, and I quote, "You have to get rid of all of your guns." He was told this by the department. He was told this by CPS. He was told this by the local prosecutor. We heard that, no, you can do these things. You can hunt. You can target practice. That's not what these people are being told on the ground level. And this has gone on for a very long time. The only way it can persist is either it's purposeful or no one's doing their job to stop it, because it's clearly wrong. To give you the gravity of truly how wrong this is, I want to tell you a little bit more about the lawsuit, what happened there that spurred this along. The child's mother abandoned the child with her boyfriend. She just disappeared. The child's boyfriend turned the child over to the grandparents. They took care of the child for a while until all of a sudden the mother shows up out of the blue a couple weeks later. She calls the state police because the parents won't give the grandparents won't give the child back because the mother is homeless, and at that time of the year it's negative 30 degrees outside in the UP. The state police say if they don't give the child back to this homeless mother, that they will arrest the grandparents for kidnapping. So eventually the grandparents give the child back. Through the next couple days, the grandmother communicates with the daughter, who's living out of her Jeep in the cold, the fact that she's homeless. Out of the blue, they get a call from a foster house or foster care facility that the mother had once again abandoned her child. And so they went and they picked up the child. And they started the foster care process because they wanted some rights in the matter. They wanted to take custody because they knew that their daughter was not doing a good job. Weeks later, the daughter comes back again. And the courts in the department decide that placing this child back with this mother, who had since moved back in with her boyfriend, who the mother had just recently called many police departments reporting the boyfriend for sexually abusing the child, they thought that was a better environment for this child than loving, law-abiding grandparents because the grandparents had guns in a safe. That's what this is about. And they've received hundreds of calls, according to them, over the past weeks, saying that they're not alone, that this is going on for a long time, all over the state. They went to people for help. They went to legislators. They went to the Attorney General's office. The Attorney General's office told them they didn't think there was anything to investigate. They went to the governor's office. The governor's office hung up on them after telling them to contact the department. They had no options left but to file a lawsuit, and the day after they filed the lawsuit is when the kid was taken from them. Please, help. This is worse than it is being made out to be. It is worse than I thought it was. The truth needs to get out there so that everybody truly understands what's going on. In talking with people that have gone through this, I do believe there is probable cause to believe that criminal acts have been committed. There are certain laws in our Firearms Act, or in our certain firearm laws, that if you break them, they have criminal punishments associated with them, and I think there is probable cause to believe the department has broken these laws. This needs to be investigated, and I hope everyone in this committee will help get this investigated and get this shut down, because nobody is being held accountable for this. As to the lawsuit in question, a complaint has been filed. I talked to the plaintiff's attorney last night. Lawsuit has been filed. The Attorney General's office has filed a brief in response defending the department, which I understand is commonplace for the Attorney General's office to defend a state agency. The Attorney General's office, I believe, has been less than honest in their brief. They have misconstrued tremendously what's going on. They are defending the policy as written. The policy as written isn't really that bad. Nobody is talking about what's really going on, the get rid of your guns completely that many, many people are being told about. The Attorney General's office also grossly misstated multiple state laws, cited things that don't even exist. It's just shocking that what's really going on and the scope to which our state government has let these people down.
Okay, well, let's not bash the Assistant Attorney General for defending the State Department. That's his job.
I
or
understand
her
it's their job, but I just
don't know
asked
who
them
it
to be
is,
honest about it.
But they can't be here to defend themselves, so let's just speak to the bill. And you think the bill is a good move forward?
It's a good move forward, but please understand it is not enough.
Okay. Questions? Senator Beda.
Thank you for your testimony on that, and I'm struck by, number one, there's a lot of complexity to this, and I could see even within the gun community, there seems to be a common theme that it still needs to be fixed a little bit more. If that's maybe not putting words in your mouth, but certainly what I heard from some of the others, it looks like it needs some more work. From your perspective, moving it forward, I always prefer working things in the committee because it's frankly a lot easier to get things done here and to address things here. From your perspective, is there anything in the bill that needs to be changed or addressed as it is stated right now?
I think it can move forward. It's good stuff. There might be some other tweaks that I might recommend. For what it's worth, I would consider this a potential concern. I don't know that it truly is or not, as I haven't had the time to investigate it. The attorney that is representing the plaintiff, last night, he recommended that something be added to the bill that prevents the department from considering firearms ownership when deciding licensing. Senator Beda, you had a question about whether or not there's a right to be a foster parent. I think that misses the issue here. It's whether or not other rights are trampled in the process of considering whether or not somebody is a foster parent. If the department were to say, well, I'm sorry, you're black, we're not going to license you as a foster parent, I think everyone would rightfully scream about that. And I see this as analogous.
Okay, thank you.
Thank you for your time.
Okay, I have two more cards to read in, then we'll be voting on this. Frank Foster from Every Town for Gun Safety Organization opposes as written. Brendan Bedreau of the National Association of Gun Rights opposes the storage requirements. Okay. I will make a motion to adopt the S1 version of Senate Bill 527. Mr. Clerk, please call the roll.
Chairman Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca? Yes. Senator Beda?
Yes.
Mr. Chairman, there are 4 yeas. The substitute is adopted.
I'll make a motion to report the S1 version of Senate Bill 527 to the floor with recommendation the bill then pass. Mr. Clerk, please call the roll.
Chairman Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca? Yes. Senator Beda?
No.
Mr. Chairman, there are 3 yeas, 1 nay. The bill is reported.
I'll make a motion to recommend immediate effect. Without objection, immediate effect is recommended. We'll now move on to Senate Bill 607. We've previously taken testimony on this. After hearing the testimony, I worked with both the Prosecutors Association and the ACLU and developed this S1. The original language was broad, so we tried to hone in on the authority the clergy has over a parishioner, make sure that they couldn't sexually assault them. This legislation would add clergy as a position of power to the state's criminal sexual conduct law. This would be similar to a mental health professional, psychologist, doctor. This would be entered as a 3rd or 4th degree CSC. 13 other states already have this law on the books, and we worked specifically with the state legislation that had been tested in court. I'll make a motion to adopt the Oh, I should say that I have a card from Kimberly Budden at ACLU that is now neutral. I'll make a motion to adopt the S1 version of Senate Bill 527. Mr. Clerk, please call the roll.
Chairman Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca? Yes. Senator Beta?
Yes.
Mr. Chairman, there are 4 yeas. The substitute is adopted.
I'll make a motion to report the S1 version of Senate Bill 607 to the floor. Recommendation has been passed. Mr. Clerk, please call the roll.
Chairman Jones?
Yes.
Senator Shoemaker? Yes. Senator Rocca? Yes. Senator Beta?
Yes.
Mr. Chairman, there are 4 yeas. The bill is reported.
I'll make a motion to recommend immediate effect. Without objection, immediate effect is recommended. We'll now take up House Bill 4463. Okay. I want to clarify, I guess I did misspeak, that we adopted the S1 version of Senate Bill 607. This, as you can see, there's a typo here. It says 527, and I was reading the typo. Okay, moving on to House Bill 4463. We have Representative Van Single here. Do we have a staff here? Yeah, please come up. Go ahead.
All right. Well, thank you, Mr. Chair. I appreciate the opportunity to talk about my bill. I know there's been several versions of this bill that have come up session after session for several years, especially for those of you that have been around a little bit longer than I have. And I would ask that you wouldn't lump this bill in with prior versions of that, as we've made quite a few changes compared to prior versions of this to try to appease some of the interest groups that have come out in opposition of this bill. And I wanted to give a full disclosure up front. I am a landlord myself. That's where some of the passion for this issue came from. I will not personally benefit from this bill, as I have my properties through a property manager, so this won't affect me in any way. So I wanted to clear that up, that this isn't in my self-interest. But this has become a problem over the years that I've, speaking with other landlords, and even from personal experience in my past, it's in your best interest as a property owner or landlord to incorporate or create an LLC to separate yourself from the liability of being a property owner, especially in the sue-happy country that we're in today. It's in your best interest. The problem with that, and no offense to my attorney friends, but it's the current climate, unfortunately. The problem with that is, as soon as you incorporate, you are now forbidden by law to represent yourself in court. And I understand the thinking behind that. You created a separate legal entity. But there probably should be some exceptions for that. And I can think of instances in the past where I represented myself in court before I incorporated. These are easy cases. You show up in front of the judge, and the judge says to the defendant, "Did you pay your rent?" "No." "You need to leave." The case is over. I don't need an attorney to do that. And in most cases, once I did incorporate and started hiring an attorney to do this, it was $1,000 by the time it's $200 an hour by the time you take some phone calls and go back and forth. It's pretty hard to get out of this for under $1,000. I am only permitted by law, or whoever files the claim, to collect up to $150. So you're out a lot of money for a very simple case that you really don't need an attorney to take care of. So what this bill does is, again, like prior versions, allows somebody that has incorporated to represent themselves in court. And there's been a couple groups, or a few groups, that have come out in opposition to this. And to try to make them happy, we've scaled this back quite a bit from prior versions to where this is just a single-member LLC. It does not allow C-corps, S-corps, partnerships, or any other variations. This is your mom-and-pop company that may be a property owner that just has one rental house that their daughter was going to college, or something similar to that. And it does have a provision for a husband and wife to be considered as a single-member LLC. But we've really tried to make this bill something that we can all get on board with, and say we're not trying to blur the lines of separating the corporation from the individual. And some of the fears that it would be like practicing law without a license, and that you would have incompetent people coming into court. Well, the defendant is not required to hire an attorney. And if you're not in an LLC, you're not required to hire an attorney. And those cases seem to work themselves out just fine. So this is just, I believe, a technicality to fix or allow people on the smaller end of the landlord scale to represent themselves. And if it means anything, there are several attorneys in the Republican caucus in the House that all voted for this bill, both in committee and on the House floor. So with that, I would take any
Do you have
questions.
any questions? Senator Bida.
You know, I kind of understand where you're coming from. I've dealt in this when I came out of law school. I actually worked for a very large law firm, and then I went for a mid-sized firm, and we represented a number of apartment complexes. And I agree, it's a kind of a simple process, but what do you think about the argument that, you know, you choose to go into an LLC because it provides certain protections to that corporation, and an LLC under the law is considered to be a person itself, a corporate, to quote former Republican nominee Romney, you know, corporations are people too. Well, they're considered a separate entity in this interpretation of law. You get certain protections for filing as an LLC, which you don't as an individual. And it seems like we're trying to change the game here a little bit on that element, and I'm a little uncomfortable with that. Perhaps you could address that.
Yeah, no, I certainly understand the argument, and I've talked to some of my friends on the other side of the aisle that shared that same concern, and we never actually did reconcile, and we fell on different sides of the issue. But I'm of the belief you don't give up your rights by signing an incorporation document. I think self-representation is a constitutional right, whether it's in the criminal court or the civil system. Yeah, that gets a little bit blurry when you start getting into partnerships and C corps, and you're a shareholder, but the
corporate entity. You're not a person. It's considered its own entity there. So when you go in there as a non-attorney and practicing law, you're practicing on behalf of another individual. And that's the rub with this. You choose to incorporate, and you get certain protections under incorporation. You choose to be a sole practitioner or just a mom and pop, you know, renting a place out, and you have a right to represent yourself. And you, obviously, that's what we're doing here. We're trying to change that. But, you know, it just seems to me that we've kind of got a solution in search of a problem, because it doesn't seem to be not working, unless you have some examples of where it's not working.
It is a problem. You know, again, going back to when I was starting out as a landlord and before I had incorporated, I had examples where I had apartments that were maybe $450 a month, and somebody would get a month behind. And I would want to proceed with the eviction process. And in that case, I still needed to hire an attorney because I was working at the time. So you would go through this thought process of saying it costs more to hire the attorney than the judgment that I'm trying to collect. Or, you know, I don't want people to be in that situation to where we let people get 2 and 3 months behind, and now it's worth it for me to go hire the attorney. It's just about giving people options. So, and I certainly understand your argument that, yes, there is a legal separation of the two. My argument is that a single-member LLC is so close to being an individual, but not quite, that maybe we can make an exception in this case. And we've narrowed this down to just a very specific group of people, a single member being a husband and wife in some cases, and nothing else.
Sure.
Because you just raised the point, how would the courts know then at that level whether you're this LLC, as you mentioned your example, versus a large corporation that owns multiple apartment units? How would you deal with that in the statute?
Good question. We had that question come up when we first brought this through the House committee, and we added an amendment to where you'd have to show proof during the court case that here's my incorporation documents. It says Scott Van Single is the sole member of this LLC, and at that point you would be able to move forward in representing yourself. So we tried to work with all the interest groups to clear up all those what-if scenarios. Yeah, thank you.
Okay, thank you. See no further questions, we'll call up Clay Powell of Rental Property Owners Association.
Thank you, Mr. Chair, committee members. First, I'm going to take a little bit of a risk because I've often been mistaken, but I believe under Michigan law that the definition of a limited liability company is actually, it's a non-corporate business entity. So technically speaking, a limited liability company is not a corporation. So I just wanted to kind of put that forward of something to think about. Second, within the current law in Michigan, corporations can represent themselves in small claims court. They can send an individual as opposed an officer or someone like that to represent them as opposed to an attorney. In fact, I think in most cases, attorneys are not allowed in small claims court. So we really see as an industry and have ever since this came out that these types of cases, summary proceedings, are actually very much like a small claims court type case. So that's where we really come down on it. It's that we're really not talking about changing anything. We're just saying that recognizing that these are small claims cases, although they include possession judgments, that they're pretty much the same thing. Also, it took a little bit of time just to look up quickly. In 2016, the cases that were before all of the district courts in Michigan, there were 210,000 summary proceedings, which is unfortunate, of course. But almost 85% of those cases were uncontested default judgments or dismissed by a party, which typically would be the landlord who somewhere along the line got things resolved with the tenant, perhaps with an off-court consent judgment or something like that between the two parties. So there is a very small number of cases that really need any kind of expertise beyond what the actual knowledge is of the owners themselves. Of course, there are cases, and that's why we asked that this bill be limited to $5,500, which is the current small claims limit. We thought that was important. It was mentioned many times over that things can get crazy, and yes, indeed they do. And at that time, of course, we would be in a position to recommend that those cases would also go to an attorney if they would go beyond that level. So as a Rental Property Owners Association of Michigan, we ask you to support the bill. We're excited that it's made it this far, and as Representative Van Singel has indicated, we've worked for many, many years on various versions of this bill, and we believe this one is the best one we could come up with to meet everybody's concerns, and I'll take questions.
See no questions, thank you.
Yep, thank you.
Judge Ward Clarkston of the Michigan District Judges Association.
Good afternoon. My name is Ward Clarkson. I'm a district judge in Corona. I am just completing 23 years as a district judge, and before that I was 10 years in the prosecutor's office. We are opposed to this bill. This bill is a radical departure from well-established case law that corporations and LLCs need to be represented by licensed attorneys. Choices have consequences. People incorporate their businesses specifically to gain protections of a corporation. There are benefits and consequences of these decisions. The benefits are usually the protections from certain liabilities. The consequences are that corporation needs to stand on its own. That is, it is a separate entity and it has to be represented by an attorney. As judges, we spend a considerable amount of time trying to help people understand decisions and consequences. The advocates here wish to seek the protection yet avoid the consequences. There are other alternatives. One, simply not to incorporate, make your choices. Unauthorized practice of law. This bill effectively allows non-attorneys to act in the role of an attorney. Again, it's contrary to well-established legal principles. Consumer protection. Attorneys representing landlords and anyone else understand there are certain unethical things they can't do, and if that is found out, they ultimately can be sanctioned and lose their license. The court has no such authority to do that when individuals. Lastly, this is just going to result in more contentious litigation and more time spent protecting the due process rights of all. We are opposed, the judges are opposed to it. We're the ones on the front line there, and we think it's best to stay the way we are. I will attempt to answer any questions that you might have.
See no questions, thank you.
Thank you.
Okay, I have two cards I'll read in. Jim Shasma of Michigan Poverty Law Program opposes. Katie Hennessy, State Bar of Michigan, opposes. Representative Van Sinkle, I polled the committee. I simply don't have the votes to move forward, and I want to make sure you know Senator Shoemaker checked on that before she had to leave. Otherwise, she was going to stay and miss her next meeting. But I had the poll at that time, and she made a decision to leave. So, seeing no further business, we are adjourned.